Welcome, everybody, to the latest webcast in the Cat and Gonzalez webcast series. Today, we are talking about Medicare secondary payer mandatory insurer reporting, civil monetary penalties, TPOCs, ORMs, oh my, all this good stuff. And I'm John Caddy, managing partner of Cat and Gonzalez, and I'm along with my two friends and law partners. First, Rafael Gonzalez, and my other law partner, Jim Anderson. So, guys, here we are. We're in our next webcast in our series of webcasts. We do one a quarter. Today, we're talking about Medicare mandatory insurance reporting and civil monetary penalties and everything that comes along with that. We are live today, the week before Christmas and Hanukkah. So, for those of you watching us live, happy holidays, Merry Christmas, Happy Hanukkah. And if you are watching us on a replay after the holidays, I hope your holidays were joyous and festive and bright, and you had a good time with friends and family, and now you're digging back in and starting to think about 2025 and thinking about, especially in the Medicare compliance space, what has been the biggest news and something that's been a long time coming, and we're now in the very middle of the implementation of it, and that is the implementation and rollout of the civil monetary penalty provisions of mandatory insurance reporting, which, you know, we got at the end of 2007 to start, became effective in 2010. And here we are almost 15 years later. Now we're actually talking about penalties that are accruing over at Medicare right now. So we're going to take 60 minutes today to talk about these issues, tell you where things stand, talk you through what potential exposure to these penalties may look like, who has exposure to these penalties, who does not have exposure to these penalties, what the dollar amounts could look like for the most non-compliant of us out there. And then we're going to wrap up talking about what our solution is in this space, walking through some hypotheticals, and talking about how the clients that have worked with us to insulate themselves from these penalties, what's been done, and kind of what that process looks like. So, Rafael, let me pass it over to you. And I know that you have a few slides that you created for us to refer to during this presentation.
So, John, as you've indicated, I think I want to start the conversation today by introducing, if you will, to our folks here, and I'm sure that everybody is significantly aware already about mandatory insurer reporting and the conditional payments, but just want to set the tone of the entire conversation, right, with a little bit about that mandatory insurer reporting. As you've already indicated, the statute was amended in 2007, became mandatory in January 1st of 2010 in workers' compensation claims, became mandatory in liability claims in January 1st of 2011, right? And the big purpose behind this mandatory insurer reporting is to allow Medicare to figure out, are they the primary payer or secondary payer? If there is some other insurance coverage out there, then allowing Medicare to take a look at that and make a decision as to whether or not they're going to become that primary payer or whether they're going to hold back and become the secondary payer, whether they're going to pay the bill or deny the bill, or whether they will pay the bill and then seek reimbursement sometime thereafter, right? So that's the original intent of this mandatory insurer reporting system. Jim, you practiced up until here recently as a workers' comp defense attorney. Over the years, how did that experience go? How did that play out in your day-to-day claims? How did that information requirement, how did it behave in your claims day to day?
You want me to be honest? Most people just put a sack over their head and pretended that it didn't exist, and just nobody paid much attention to it all, to be perfectly honest. The thought was that in Mississippi, where I was practicing, was such a small state that there were other larger fish to fry, and that they would not be coming around to us to try to bother us with things like Medicare set-asides and recouping conditional payments. Of course, In the teens, that began to change rather dramatically, and some attention was finally given to it, and there were efforts made to comply to the extent possible. There was still an awful lot of confusion about so many details. That's one of the things that is so good about Katie and Gonzalez. Have always been the one that's a leader out there, sharing information with people so they understood how to respond to the law that they were dealing with. And I'm excited to be a part of that evolution and see the way these things are changing right now.
Jim, I appreciate that because I think it's honest, right? That there was such a disconnect between, the technology aspect of a claims-driven organization and a practitioner, right, on the ground with the case in front of them. Those two items seem to be very disconnected in as far as this mandatory insurer reporting, at least when the system and the process first got started. Everybody, I think, out there probably knows, right? Submission of this data to CMS, done electronically. So there is an electronic file with, more than 100 pieces of data here that goes over to Medicare on each and every one of these claims. Or direct data entry, right? Medicare has built a portal for smaller entities that don't have more than 500 reportable claims a year. And they've built a portal where you can literally manually enter that information over to Medicare. So Medicare has now, over the years, provided, different ways that this data, this information gets over to them. But the purpose of it is to make sure that Medicare is informed about whether or not they are the primary payer or whether they are a secondary payer. John, let's talk a little bit about these civil monetary penalties. I think you indicated already, it took Medicare a while, right? This was, it was in the statute when it first passed, and there were multiple attempts at trying to get rules and regulations that really gave us the details of this particular process. But after a couple of times, it didn't come through. We now finally have some civil monetary penalty final rules. It's really what brings us right to this conversation today, right?
That absolutely is. I mean, the statute as originally amended back in late 2007 included a mandatory $1,000 per day penalty per file for noncompliance, no discretion within CMS. We know that the SMART Act in January of 2013 amended that to make that mandatory non-discretionary penalty an up to $1,000 per day per file penalty imposed at Medicare's discretion, after which time the question then became, okay, well, when does Medicare have discretion to penalize non-compliant parties, and under what circumstances would it exercise that discretion? So for several years, back in the 2010s, that became a point of conversation and a moving target. And eventually we got to the point where we had some proposed regulations around 2017, 2018. Comments were submitted. 2020, 3-year period started, and there you go. In October of 2023, we get final regulations regarding these civil money penalties, or CMPs for short, published in the Federal Register. And you see the citations to the relevant parts of the register there for those of you that want to do a deeper dive on the language there. Specifically, the regs became applicable just a couple months ago. October 11th of 24, they became applicable, but they're not going to begin being enforced until October 11th of 2025. Why is that, Raphael?
But John, they've given us, by way of these Code of Federal Regulations, a year, 365 days, within which to report these items on a timely basis. So they announced the rules on October 11th of 23. They began the clock, if you will, right, on October 11th of 24. And that clock is now ticking, as you told us in the introduction of the webinar, because a year later, on October 11th of 25, now entities who haven't done this appropriately are going to be untimely. and potentially open to these civil monetary penalties. So plenty of time, right? And they announced this process of the rules had been in place for a couple of years, gave us plenty of times leading up to the 23 finalization of these rules, a year within which to make sure our houses are in order. And that's what we're ticking on right now, with a year later, October 11th of 25, the moment where now, if you have not reported these items on a timely basis, you're now in violation of the rule, and now you're opening your institution up for potential civil monetary penalties.
Yep. And that's the important point here, is that even though these penalties won't begin to be enforced until October 11 of 25, penalties are accruing as we speak today. Okay, so for those RREs out there that are non-compliant for whatever reason, the penalties are accruing as we speak and are moving forward. And unless those files are remedied, then starting in October of next year, you may begin to expect to see correspondence from CMS regarding the penalties being asserted against your organization.
The significant safety net here for all of those listening to us is the event, the triggering event that starts off this process is ORM, the acceptance of ongoing responsibility for medical, and or a TPOC, a total payment obligation to claimant, a settlement, judgment, or award. Both of those events must happen after October 11th of 24 for that statement, John, that you've already indicated to be true, which is the clock is now on, right? You've got until October 11th of 25 to report either an ORM, you've accepted ongoing responsibility for medical, or you've settled the file. You've got until October 11th. If that event happened after October 11th of 24, you've got October 11th of 25 to report it on a timely basis. If you report thereafter, now you violated the statute.
That's an important point to emphasize.
Rob, as I understand it, they are considering both the ORM and TPOC a record, so that it's theoretically possible for each of them to result in a penalty. We'll have to see how that plays out, but I think that's what they were trying to do. Is I appreciate what they are telling everybody, that they're going to do the drawing of 250 records as of January 1, 2026. And that's when they will take a look back at this October to October period that we are now in the middle of. And they're going to select 250 cases per quarter. They're going to break it down between the group health and the non-group health cases. And depending on the proportion of the group health to non-group health cases that have been reported, that's how they're going to do their selections. So if, as an example, if 60% of the cases reported were non-group health, 40% group health, out of that 250, 150 of those cases will be non-group health and 100 will be the group health cases. And then that's when they will start looking at it and they're trying to collect some money. As I appreciate it, they'll send a first letter notice. The RRE has 30 days to respond, and they have said there will be no extensions granted. You've got 30 days to respond. If you do respond within 30 days and have a mitigating factor or an explanation for the delayed reporting, then they'll consider that. But if it's then rejected, they'll do a notice of non-compliance and intent to impose a penalty. And at that point, the RRE can request a hearing within 60 days. An ALJ decision would be handed down, and after that decision, within 30 days, it could be appealed to the appellate division, and then that becomes final within 60 days unless a petition for judicial review is then filed. So there's a long process before the money actually starts being collected. But once all the appeals have been exhausted, the notice of final determination will be issued, and that will tell the RRE how to remit payment and when it's due. Now, they have also specifically said that these penalties are going to be enforceable against the RRE and not against the reporting agent. So a lot of people, I think, have been trying to hide behind the fact that they have an agent taking care of all that for them. And as we have found, and the very reason for our being here talking today is because of the need to see what's going on in your records and see what you can fix. As we described it, an audit of the reporting processes in place so we can fix ahead of time and minimize penalties as best we can. It's a very significant change in what's been done in the past that everyone should be paying close attention to.
Absolutely right, Jim. Right. And I think early on you mentioned two different things, right? So there's two components to be concerned about, ORM and TPOC, right? We may not worry about ORM, for example, in a liability case, but in a workers' compensation case, in a no-fault situation, you're absolutely right. They're measuring the timeliness of that RRE reporting an ORM early on in the life of the case, and then a TPOC at the very end of the case, right? So you're absolutely right that there are two possible things going on, even though they live within the same file, two separate tracks for possible civil monetary penalty. So a lot of folks may have thought that there's only one. No, these two are independent, and there is a separate responsibility to timely report both of those items. Again, they've given us a year, right? A year from the date of the event, right? So if that event, for example, although it's not applicable as of today, not yet, but if that event took in place today, we would have 365 days from today, right? So we know that any ORMs or settlements that took place after October 11th, that year now carries with it that event, when that actual reporting date would apply to that particular entity or institution. John, tell us a little bit about what these fines look like, right? What are they going to be stagnant? Because the statute said up to $1,000, but this rule finally gave us a little bit of detail in what they meant.
Yep, exactly right, Raphael. So in the final regulation, it's not flat $1,000 per file across the board. It is a tiered approach based on the duration of noncompliance, right? So if a file is at least a year old, but not yet 2 years old and late or non-compliant, the fine is $250 per day per record, which means per file per Medicare beneficiary. If the file is more than 2 years out of compliance, but less than 3 years out of compliance, it's $500 per day per file per record. And then if the file is out of compliance for greater than 3 years, $1,000 per day per record. But here's the little extra kicker to this, is that it's not going to be $250, $500, or $1,000, because within this regulation, we know that these CMPs, these penalty amounts, are adjusted annually for inflation purposes. So it's not $250 today. It would be $357. It's not $500. It's $714. It's not $1,000. It's actually $1,428 today. And as time goes on, those amounts will increase. So what we're talking about here are potentially significant penalties due to process flaws in an organization's reporting method and process for reporting these files up to Medicare. If there's one way that their process is flawed, which leads to non-compliance, then we're not just talking about one file potentially that's out of compliance. We might potentially be talking about every single file that's getting reported to Medicare involving a Medicare beneficiary because of the process flaw that then leads to these potentially significant penalties.
John,
Well, one of the things that they have also said, just to add on that, the maximum penalty is $360,000 per incident. I take that to mean that if there were 2 records that were found, the maximum would be $720,000 in penalties. I don't think we'll reach there since they're beginning with this single year that they're looking at. There won't be enough time to elapse, I don't think, to run down $360,000 worth of penalties. But I believe that same federal regulation is applicable to adjusting that number to a cost of living number. And I understand that 360 under that current cost of living increase would actually be $538,010. So these are huge penalties that we're talking about, and they are designed to get the attention of the industry and require compliance.
Absolutely. And as I put in the chat, guys, if anybody who's watching has any questions, go ahead and put them in the Q&A or in the chat, and we'll field them as they come in the door. Okay. Ralph, go ahead.
Jim, I don't, because of the statutory language here, up to $1,000 per day per file. Medicare interpreted that to say, okay, the most that we can ever on an annual basis fine somebody here is $365,000. But because, as John indicated, because of the, and I mean, literally 45 CFR 102.3 makes it clear, right? Because of the federal government's ability to annually take a look at that number, right? What may have been 250 is now 357. So that means you can only still fine me 365,000, but my daily rate just went up, right? So if somebody was more than 3 years late and they were only late, let's say for 6 months, although by then it'd be more than 3 years, right? They would fine me $1,400 and some odd dollars today. We know that if that happens 3 years down the line, the most that they can fine somebody would be 365 on an annual basis. On a per day, if it's less than that time period, that's when they're going to use the higher daily rate. But on an annual basis, because of the statutory language that says up to $1,000 per day, I think they're going to have to limit themselves to 365. But you present a pretty interesting issue, Jim, right? Will CMS get aggressive on that, right? Will they try to reinterpret that provision? I mean, based on other civil monetary penalties, I don't know that they've got, an argument there, but you never know, right? Weirder things have happened with CMS.
Right.
Yep. And guys, just a point of clarification before we move on. Because in the slide we have per record, and a question came in, what exactly does that mean? And what that means is per Medicare beneficiary, right? So each time that an RRE is reporting up to Medicare on a file or a record, they're doing it on behalf of one Medicare beneficiary and reporting a lot of information and data about that one Medicare beneficiary and the details of the ORM or TPOC event up to Medicare. So if you're an organization who, say, is reporting 100 records to Medicare every quarter, that means you're reporting information about 100 Medicare beneficiaries a quarter. So if your process is flawed and out of compliance, you're potentially on the hook to Medicare for penalties related to those 100 records that you're reporting.
John, let's go a little deeper on that. What if that one claimant has had 4 dates of accidents in the course and scope of employment over his 20 or 30 year work history with this particular employer?
Yeah.
Each of those are a separate record, right? Even
That's right.
Claimant and same employer carrier, each of those accidents are a separate record. That means, Jim, you've already indicated it, you've got the responsibility to make sure ORM and TPOC is reported timely in each and every one of these dates of accidents. Otherwise, opening up yourself for potential civil monetary penalties. So it becomes that double, triple whammy, right, if you will, if you've got individuals with multiple dates of accidents. So John, a lot of folks have been coming our way even before the rules were final, but certainly after the rules became final in 2023, when they were first put on paper and announced to the world, trying to find assistance, right? Trying to find some help in managing what clearly has become an exercise of collecting data and dumping it at CMS, right? That seems to have been, I don't know, I'm trying to simplify it, right? But the behavior of most folks out there was Medicare isn't looking, Medicare isn't doing anything about it. I just need to plug my data, put it in the system, report it. That has now changed significantly. It matters what's in there, and it matters when you report it. So a lot of folks are starting to sort of rediscover mandatory insurer reporting. And they've been asking us for some assistance and some help. John, what's been your solution to the clients? What have we been offering our folks?
Yeah, you know what, Raphael, for years, payers have been on autopilot, I think, with their reporting up to Medicare in this space. They just were concerned about getting it done. In fact, you know, I dare say that there are a lot of organizations potentially that haven't even signed up as an RRE yet, quite frankly. But for those that have and have been going through the reporting and submitting files every quarter timely within their 7-day window, it's been more about getting the data to Medicare and less about how clean is the data, right? And we know now that it's important that the data not only is delivered timely, but it's clean too, proper, appropriate, because the data gets submitted to Medicare. It plays a great role in Medicare making decisions on a particular file for a beneficiary when it comes to conditional payments, when it comes to Medicare set-asides. So the data not only needs to be timely, but clean in that regard. And, you know, as these regulations were finalized around the civil monetary penalties, and as the clock has been ticking, and we're getting closer and closer to October of 24, and now with that in the rear view and looking forward to October of 25, we're having more and more people who are asking us, hey, I work with a vendor, I've got someone who's doing this reporting for me, but I want to make sure that it's being done the right way. And, you know, asking them to audit their own process doesn't make a whole lot of sense. I'd like to get an independent set of eyes on this to make sure that it's being done the right way, the proper way, compliantly, with clean data. So, you know, we have had clients come to us, talk with us about reviewing their reporting process, taking a select number of claims and reviewing the files, reviewing what's getting submitted to Medicare, and then coming back to the client to say, hey, your process is compliant based on our review and you're good to go with the way you're doing it, or your process is somewhat deficient for whatever reason. And here's where it's deficient. And here are the suggested revisions you should make to bring it up to code, bring it up to standard, to make it compliant with what CMS is looking for and expecting to receive.
John, you bring an excellent point, right? That a lot of these folks already have a reporting agent, right? And they are obtaining that data from the claim file, inputting it into the system, and out it goes. The reality of it is that reporting agent isn't looking at the substance of the information in that data, right? How would that reporting agent know whether the right ICD-10 code is being reported to CMS? How would that reporting agent know whether the right ORM date is being populated? How would that reporting agent know whether the right TPOC date and amount is being included in here? They wouldn't, not unless there is a deeper dive into the substance of the file, a review of the actual evidence, a review of the medical records, of the settlement documentation, of the acceptance of that claim and the body parts that have been compensable if it's a workers' compensation case or a no-fault situation, for example. So that's where we have taken this deep dive. And these audits are, they're difficult because essentially you've got to go into the depth of the life of the case to be able to then take that information and help the client decide, yep, you made a mistake in reporting the ORM, or you reported the incorrect ICD. There are a number of them here that do not have anything to do with the original compensable injuries. So that's the solution, right, that we have provided to the clients, not just a cursory review of whether these things are being populated, because we know the reporting agent is doing that, but whether the substance of the information that's being populated is correct, given the facts and the components of each specific injury and file that we're looking at. So these audits, John, for our clients, what we're doing is not just looking at ORM, ongoing responsibility for medicals, but we're also looking at TPOC, and we're also looking at the effect of all of that, and you've already indicated it, which is conditional payments, Medicare set-asides. How is that information, whether right or wrong, been living in these, really the main components why MIR exists, which is really all about the conditional payments and making sure that future interest are considered appropriately. Let's talk about the ORM errors, and we've helped clients that are small in nature, medium, and large. We've had clients with just a few dozen files that we have audited, and we've got clients where we've had thousands of files that we have audited, right? And again, deep dive into the substance of the facts, if you will, of everything that's going on in this case. 3 items that we primarily focus on when we're talking about ORM, and that's the ORM acceptance date. When is the date that that institution agreed to accept the ongoing responsibility for medical care related to that file? A lot of folks are mistaken that, oh, it's when I first pay that first bill. And if that first bill doesn't come for a month or 3 months or 6 months, then I don't accept ORM until the bill comes. Well, that's not necessarily following protocol that CMS has followed. CMS wants, as soon as you have made a legal determination that you are the ongoing responsible entity for that medical care, and that may be immediately right after the date of the accident, that's when, at least from a compliance perspective, CMS would like you to accept that ORM. So we have found quite a number of errors in reporting what seems to be the simplest aspect of ORM, which is the acceptance date. John, you know it better than I do, right? Probably the one thing that we see just a huge amount of mistakes in are the codes, the ICD codes, right? The ORM codes. In other words, part of the reporting process is tell me what medical injuries you have associated with and have accepted, right, ongoing responsibility for. And we find a lot of errors in that, right, John?
Isn't that the truth? Sure do. Probably more than any other field, perhaps. And the ICD-10 codes, the injury codes are perhaps one of, if not the most important fields to get correct, because what you're doing when you're reporting these injury codes is you're telling Medicare what particular body parts, injuries, or conditions are related to the claim that you're accepting responsibility for medical for. Medicare makes a note of that on their side. They are going to, when they receive medical bills from providers, hospitals, etc., and they see those injury codes, they are going to deny reimbursement to those providers, and they're going to turn it back around and tell the provider to go collect from the patient, the Medicare beneficiary, or go get paid by other means, because it's not Medicare to reimburse you under those circumstances because you reported ORM for that injury code. We see that all the time when it comes to conditional payments, right? As far as Medicare saying, oh, you reported this injury code as compensable. It was on your ORM report or TPOC report, And we've made payments related to that particular injury code. So now we're seeking reimbursement from the responsible party for that. And guess what? Once April of 25 comes and MSA data reporting becomes mandatory, the same is going to apply when it comes to future medicals with those same injury codes. So the ICD-9, ICD-10 codes now that are getting reported, super critical to get correct.
That's one of the reasons that whenever I'm talking to attorneys, I tell them when they get ready to do their settlement documentation, that they pay attention specifically to those codes. Sometimes it even is necessary to compile a list of those that are accepted claim, and that means that somebody's got to look through those records and decide at that point what is related and what is not related, and pull them out so that if there's a conditional payment claim post-settlement, there's an established trail that no, not all those ICD-10 codes were related to the claim. Those are separated out and found to not be related. It's just requires more work on the part of the attorneys to get that right.
Jim, you're absolutely right. And what we've learned is that more and more CMS is relying on that mandatory reporting, whatever that payer has said, here are the codes related. If you've reported them, Medicare is going to hold you to them, right? Here come the conditional payments, John, as you've indicated, with all of those incorrect ICD codes attached to them. And now, of course, immediately everybody wants to dispute them and appeal them. And Medicare said, how can you appeal denial of this when you have voluntarily reported this thing over here as a compensable part of your claim? So now, in order to win that argument, you've got to go back into your MIR system, make sure that those codes are correct before you can then dispute these charges that are clearly unrelated to your claim.
Raphael, all this is related. It's all interconnected. These don't live in these three individual silos. So we don't have reporting over here that is separate and apart from conditional payments right here, which is separate and apart from MSAs, right? All of this plays into each other. And it's this reporting that links everything together. And part of the reason why we have these civil monetary penalties at this point is to hammer home the concept that this is important. Medicare needs this data. It needs the right data. It needs timely data because it has to use that data for coordination of benefit purposes.
So true, John. You're absolutely right. The other aspect of these audits when it comes to ORM, so we've spoken about ORM acceptance and the ICDs, the medical codes associated. The other aspect that we focus on heavily is that ORM termination, which again seems so basic. Of course, that's your date of the settlement, right? But what we've learned is sometimes the date of the settlement can be tricky, and sometimes the amount of the settlement really confuses folks, right? So that date of the settlement, if it's a verbal agreement, it might be the day that both you and I had that phone call and we said we're done. But if it's in writing, it may be the day that both parties sign off on it. If, you know, the state requires or the parties require taking that signed stipulation over to a judge, it might be the day that the judge signs that order, right? Sometimes by agreement is the day upon which payment was made. Sometimes is the day in which that check was received by the office. So the date of settlement, and Jim, I think you're onto something here, is defining all of that in your mediation agreement, in your stipulation, making absolutely sure that that's been defined so that there isn't confusion when an RRE gets to report this ORM termination date, because we know that's going to have meaning from now on, right? If late, there may be penalties associated with it. When the other things that we always see, right, with regard to this particular is when can you terminate the actual case, if you will, in this regard, right? And sometimes folks especially, for example, workers' compensation cases that have been around for a long time, you know, a year or two into it, they just terminate that ORM. Well, we've learned that that's not appropriate, right? There has to be medical documentation that the claimant no longer needs medical care, or that a judge has said it's no longer compensable or no longer related. The one exception that they have given us, CMS, is if you have a claim where you've spent less than $25,000 in medical, and it's been more than 5 years, you know, since you paid anything on that file, then they will allow us to terminate this ORM for the moment. If that claimant comes back because medical's still open, then you've got to reopen it again. So they have given us an exception within which a time period within which to terminate that ORM. All of that gets confusing for folks out there, right, John? Those are the kinds of things where at first glance you say, how in the world can anybody go wrong on terminating ORM? But here we go.
Ralph, all this stuff is much more complex in practice than it is out in the field when you're resolving a claim. You know, these are afterthoughts for the claims professional more often than not. These are afterthoughts for the attorneys representing the parties more often than not. These are complicated, complex issues where accuracy is important, timing is important. And this is the reason why we think it's so important just to educate folks in this kind of way, to emphasize the importance of better understanding of these obligations, having a plan going into this as far as a process, a protocol that is tested and passes muster in that kind of way, and that you're utilizing on a case-by-case, claim-by-claim basis.
That's super important, John, because cookie cutter doesn't do it here. You've really got to dive into each and every claim, and you really have to review the circumstances, the facts, the issues, the back and forth, right, to be able to make that determination. What is the right ICD? What is the right ORM acceptance date? What is the right ORM termination date, right, if the parties have decided to do that? So that really is, that's key to all of this. That one template doesn't provide the answer for it all. You really have to be detailed about the issue and the facts of each case. Which brings us to the TPOC errors that we've also found in some of these audits, John. TPOC, total payment obligation to claimant. Again, you're thinking settlement, judgment, award. How hard can that be, right?
It is. Our audits have revealed that folks are getting this information incorrect based on our review of the files. They're putting in the wrong amount for the TPOC amounts. They're putting the wrong dates in as far as when the TPOC occurred. If you can believe that, you know, you would think it's simple. It's not. And then all of that through this filter of the TPOC threshold, which we know just got announced earlier this week, right, Rafael?
Yep. $750 still remains the threshold. So any case that settles for more than $750 must be reported. Any case that settles for less than $750 does not have to be reported. If it settles for less $750, not only does it not have to be reported, Medicare will excuse conditional payments on those filings, right? So it's a low dollar threshold to try and work with folks on what they consider to be minimal files. But any settlement over $750, there's an obligation to report that case through the mandatory reporting system. And so that's what we're talking about here, this reporting of TPOC. John,
So
go ahead.
Yep, guys, I know we're going to get to some hypotheticals here in a minute, and we're gonna stay true to our 60-minute promise. We're going to go over time answering some Q&A here. There's a lot of good questions that are coming in here, but one question I want to address now before we get to the hypotheticals has come in. Does the RRE need to be concerned about any cases or claims settled before October 11 of 24?
So that, again, ORM happened before October 11th of 24. TPOC happened before October 11th of 24. Hopefully, all of that was reported, right, beforehand. But because it happened before October 11th, not going to be on the bullseye for civil monetary penalties. This clock started ticking for events happening after October 11th of 24. So if ORM or TPOC happen after October 11th of 24, clock is on. If it happened before, hopefully you reported it because that was still the law, but no timing component applicable, no civil monetary penalties applicable. Hopefully that answers that. John, with regard to the TPOCs, what we noticed that confuses folks out there is people always ask, is it all medical expenses? Yes, it is, whether Medicare allowable or not, right? Because folks, I think, have this thing, well, my MSA is only for MSA allowable, Medicare allowable expenses. But when deciding TPOC and evaluating that TPOC amount, it's all medical dollars, even those that are non-Medicare allowable.
It's everything.
Everything. Lost
It's everything.
Property damages, attorney's fees, costs, that MSA allocation. If you're annuitizing it, it's not just the cost of that annuity, but the payout over the life expectancy.
Yep.
Any liens reimbursed. John, you said it. Everything gets included in here.
It's
right?
that top line number on when the case is getting resolved. What's the top line number? Don't worry about liens. Don't worry about MSAs. Don't worry about what plaintiff's attorney is going to take his fees, what costs or expenses are on the file. Don't worry about indemnity versus medical. We're talking about the top line number to get the claim resolved. That's the TPOC. That's the amount that you need to be concerned about getting right when you're reporting to Medicare.
And John, we do a lot of liability work for folks out there, oftentimes that maybe have a workers' compensation claim component attached to it. That confuses folks. What if the employer carrier is waiving, right, its reimbursement right? That under the state law, they have a right to reimbursement from proceeds of that third party. What if COMPA said, I'm not going to pay anything on the case, I'll waive that lien. You can keep your third-party liability settlement intact. Well, part of the settlement TPOC here is the value of that waiver must be included. A lot of folks get really confused by that as well.
Again, complicated issues, right? That are not given enough credence and attention out there in the field on a day in, day out basis. And our audits are revealing these errors that are occurring. And good thing that we're reviewing it and catching those. Yeah. So that CMS isn't the one who's catching them.
That's absolutely right? Because that's the danger here, that you may have reported an incorrect amount, right, that now matters to Medicare in as far as, potential reimbursement of conditional payments, Medicare set-asides. So, and John, I think CMS has hinted more than once about False Claims Act claims, right? Because a lot of folks may say, but if I did it timely, right, I may have walked away from civil monetary penalties, but it isn't just these penalties that we're talking about. There's other causes of action out there.
Again, these events are not happening in isolation. Just because you are checking a box regarding your civil monetary penalty exposure, if you're doing that in the improper way and you are potentially perpetrating fraud against the Medicare system, then other federal laws like the False Claims Act, etc., may be coming into play. And Medicare officials over the most recent years have, with more frequency, made reference to that statute and to those penalties, which carry treble damages plus individual fines of anywhere between $10,000 to $21,000 per incident.
Yep. John, I think we've spoken about, we're going to hit some examples here. I think before we dive into them, and the three of us have had this conversation that the entire either MIR or civil monetary penalty conversation has so focused on workers' comp. A lot of folks out there forget that this applies to no fault and it applies to all liability claims, med mal, products, you name it, it's applicable, right? Those institutions, those responsible reporting entities in liability claims have the same obligations. If they didn't accept ORM, right, and in most liability cases you wouldn't, okay, that's off. But this TPOC issue is a component of the equation that must be reported to CMS on a timely basis. So I wanted to start these examples in that conversation by, let's focus on these liability issues and situations, because they seem to be almost put aside, if you will, right, John? I mean, I think we've mentioned that before.
We the three of us and our firm, we've been a part of the national conversation when it comes to Medicare compliance for many years. That conversation has been weighted fairly heavily on the workers' comp side of the equation. And I think that the general liability folks may have been missing the importance of paying attention to this all along, by and large. Because there are no real ORM events on a GL case, on a general liability case, but there are TPOCs, and the rules, the penalties, the reporting applies to liability RREs just as does workers' comp in that kind of way. So wanted to spend a couple minutes here with a few hypotheticals that are liability focused to spotlight from a timing perspective when someone might be exposed to these penalties if the data they're sending is not timely or insufficient.
Got it. So this first one, liability case, did not accept ongoing responsibility for medical, right? So essentially, the entity, the responsible reporting entity here, did not check yes. As a matter of fact, they checked nothing. They left it blank. That's okay. That's an appropriate mechanism, if you will. It won't get you into trouble. So ORM and potential civil monetary penalties out of the way. What is at stake here is that TPOC, that settlement. And as you can see here, the case settled on February 1st of 2025, right? So it happened after October 11th of 24. And so they reported it on April 1st of 26, clearly more than 365 days from the date of that settlement. And that's where the violation here comes in. And John, we've given it some monetary value for folks to really start thinking through, what does this mean? What do you think about that?
Yeah, absolutely. So if this claim was resolved February 1st of 2025, the RRE in this situation should have reported this during the second quarter of 2025, during their assigned 7-day window. They missed that window. They missed the window in Q3 to report it. They missed the window in Q4 of 25 to report it. They missed the window in Q1 of 26 to report it. And finally, April 1st, here we go. Report goes to Medicare. And it's that period of time that is being calculated at $250 a day for a CMP of $14,500. Okay. Now, that's the base penalty. If CMS chooses to adjust it for inflation, that gets ratcheted up to that $20,706 figure you see at the bottom of the slide. So because in this one case, this one Medicare beneficiary, this one TPOC that was late, we're looking at potentially $20,000 or more in penalties for noncompliance.
Yep. Here's another one of those, John. Here's a no-fault situation. And in no fault, much like in workers' comp, it's ORM driven, right? You've got to tell Medicare if you have accepted ongoing responsibility for medical. And here, clearly, this institution did not do that on a timely basis, right? Car accident on March 2nd of 25, reported the incident to the carrier on July 20th of 25. I'm sorry, it doesn't get reported to the carrier until July 20th of 25. So they don't know about this particular situation until then. And then once learned, they take more than a year to get it over to CMS. They do that November 15th of 26. Same scenario as you just indicated here, because it's more than 365, right?
Yep, that's right. And important to note for everyone out there watching this, Medicare won't penalize for that period between March 2nd of 25 and July 20th of 25, because the no-fault carrier didn't know that the incident had occurred, but they were notified of that on July 20th of 25. So any CMPs that would accrue based on that date of being put on notice of the incident.
Yeah. And I think a third example here, and this is a workers' compensation case. Jim, you and I were talking about this situation where, for whatever reason, and in this case, denied workers' compensation case. So they do not accept ORM. And maybe because of that circumstance, the file just doesn't get the right attention, right? It never goes through this Medicare process. So nothing is reported as far as ORM because it's a denied case. They settle the file and they blow right through that as well. They don't report a TPOC. And it is the claimant attorney who goes to the BCRC, John, trying to, denied case. The CRC doesn't have any numbers. They've got to go to the secondary contractor, the BCRC. The BCRC does find conditional payments. They provide all of that information to claimant counsel. Now that file is on the radar. CMS brings it up on their own as one of those 250 per quarter or one of the 1,000 cases, Jim, right, that you talked about earlier. And now Medicare looks and says, wait a minute, clearly BCRC driven, nothing over here at mandatory insurer reporting, neither ORM or a TPOC. And that's what gets this particular institution into trouble, right, Jim?
Absolutely right. And that illustrates so clearly what these audits can do for the RREs. They can find these problems and get them fixed and try to minimize or eliminate any penalty possibility, because as we've said, they are going to be expensive. The good news is that there won't be but 1,000 a year looked at. So it won't be a whole lot of cases, and the odds are everybody won't be penalized. But getting it in order so that they're not penalized, this is just starting. Think what's going to happen 2 or 3, 4 or 5 years down the road. They're not going to have that one window of compliance that everybody's looking at right now. It'll be a much longer window, which would create much higher penalties as well. So trying to get it right now is what the goal should be.
Couple of points to that, Jim. We get asked all the time, are they going to stop at 1,000 files on an annual basis? Are they going to increase that to 2 to 5 to 10,000? Right. And my anticipation is that they will. Right. This is the beginning of this process. They got to try it out. They got to figure, and feel their way through it. But I am anticipating that number will increase significantly, especially if it will be driven through, right, technology that would allow them to touch a great deal of many more files. So what do you guys think about that? Are we going to stop at 1,000, or do you think it's going to be later on?
It will grow. It will grow. I think that when you look at the reasoning behind the requirements for reporting cases, reporting the TPOC on every settlement of more than $750 for a Medicare beneficiary as of April 4 of this year, there's a reason they're collecting that data. And I think it would make an audit much simpler for them to go back and find the folks who have been non-compliant there. So it'll be interesting to see how it evolves.
Jim, I'm going to take a little more conservative take on this, okay, because I think for me, the willingness for the government to ramp up the number of files that it's going to be looking at will be determined based on what are the results of the initial audits that they're finding. Especially given the new administration that's coming in, right? I think if the audits reveal a lot of financial non-compliance in this area and are yielding great amounts of civil monetary penalties that can be accrued, I think that the dollars would make sense to invest in this type of program to ratchet that up, right? It seems like the new administration is all about efficiencies and trying to make things more efficient, more economical, etc. If the audits reveal lots of financial penalties are available, I suspect more dollars will go into the program to increase the number of files they review. If it turns out that they're not, I could see them saying, you know what, we're not going to invest any more resources here. We will continue to select this amount of files every period, and we will review this amount of files, and this is what it is. Doesn't mean that non-compliant REs are out of the woods, though.
Yeah.
No.
It just means that potentially we're looking at this static amount going forward. But it is going to be interesting, and not only when it comes to this issue, but as you know, in a lot of other areas of Medicare secondary payer, how a new administration is going to view these individual obligations.
The other thing that this example brings to light is CMS, by bringing, plucking that case out of the millions out there, brought an end, if you will, to the time period of late reporting. Had they not done this quarter, right? If this thing lives another year, another 3, another 5, another 10 years, it doesn't get caught, but somewhere down the line, it gets plugged. Oh my goodness gracious. That's a $365,000 per year case times whatever many years that thing has been unreported, right? So to some degree, you want to say, okay, 41 doesn't sound so bad, considering if this thing had gone on and on and on, what that number could have been. So yeah, John, I'm interested. We'll follow this carefully to see what that activity looks like and whether CMS internal says there's money here, let's go spend because there is an opportunity to collect even more.
So guys, we've had a couple questions come in.
Yeah.
Why don't we go ahead and tackle those, and then maybe we'll start to wrap things up and give some practice tips and advice about what folks might want to consider doing going forward. So first question that I've got here, what impact do you see this having on MedPay on a CGL policy?
MedPay, considered no fault by CMS, right, will have 2 responsibilities, ORM. I know that some carriers out there settle that potential exposure, right? It may be minimal, it may be $5,000, it may be $10,000, and some carriers would prefer to just write that policy limit out and give it to the claimant. That would be considered a settlement. That's a TPOC. So in some situations, that no-fault insurer is going to have both an ORM responsibility and a TPOC responsibility. If that carrier doesn't practice in that manner, but reimburses providers on a bill-by-bill basis and waiting until exhaustion, then once that policy limit is in fact exhausted, then a termination of that ongoing responsibility would be appropriate. So not letting it linger and open, because that would create at CMS's eye the thought that this entity continues to be the ongoing responsible entity for all medical care. So if there are conditional payments, they may push them out to that no-fault carrier. So there is a purposeful here. If you've accepted ORM, when do you exhaust your policy limit to then say terminate ORM?
Perfect. Thank you, Raphael. Next question that came in here through the chat. My organization occasionally writes off hospital bills, which I understand may be considered a TPOC. Maybe others are doing something similar or issuing advance payments while considering compensability. Do you have any guidance in those situations? My state has a 1-year statute of limitations.
John, we get met with this question quite a bit. We do a lot of work for hospital entities around the country. Clearly, as we've already indicated here today, if right? There's a waiver of benefits or bills of less than $750. That's a non-reportable TPOC, we're good. But if the value of what's being waived is greater than $750, there would have to be an examination that may be considered a TPOC under Medicare's rules, and therefore you'd have to make sure that gets reported to CMS, right? On a timely basis at that. So there is a real fine line, if you will, of making sure that you're following the rules there.
All right, how about this? Are RREs actually waiting over a year to report TPOCs historically?
What do you think about that, Jim? Is that something that's at least in the workers' comp arena? Are folks waiting a year or more than a year to report TPOC?
I think that the system has been improperly implemented by many, and I think we'll find instances where they have not done it right. We'll also are cognizant of the fact that many times the reporting responsibilities are delegated to one of the lower paying clerks, thinking that it's only an exercise that a clerk can handle without properly considering all the details that are involved. And so therefore, yes, there are instances where things are that old or older. I recall one of the clients you were doing during the audit of, and I think you had a comment of something dating back to the 60s. Just hadn't been handled right since then. So there are instances of nightmare situations out there. Not 100%.
Thank goodness. Thank goodness. Yeah.
Thank goodness.
So in comp, especially if it's a large carrier or large TPA, right? And most of those entities have a reporting agent. They have programming internally to make sure that, once a settlement is in fact produced and processed in the system, that normally is taken care of through the mandatory reporting system. It's in liability cases, right, that we generally tend to see this. And it may be as a result of finality of the settlement, took a few months. Maybe there were lien issues. Maybe there were components, of an estate. Something happened that just elongated, right, the process of the settlement. And it was all said and done 6, 8, 9 months later. And then somebody just forgot to put that period at the end of the sentence by reporting that TPOC. So we do see situations where, sometime later, sometimes years later, upon a review of an audit, these things have not been reported over to CMS, right? The good news in these older files is that if the TPOC happened, 5, 10 years ago, we're going to be okay. We're going to report it today, but since that event took place a long time ago, we're going to be just fine in as far as civil monetary penalties. So no one out there should be afraid to enter this picture, enter the fry, if you will, and say, oh my God, what have I done to myself voluntarily picking up the possibility? No, we're going to be okay. We just have to make sure that this process exists internally as of October 11th of 24, and that it gets handled appropriately thereafter.
Absolutely. Last question that we have in the queue. Do you see a big disconnect between the dates that an ongoing case's medicals are suddenly denied on major contributing cause or statute of limitations, new accident, or no longer medically necessary, and the date the compliance officer actually reports the denial to CMS? Meaning, if the adjuster denies back surgery on one day, but compliance doesn't notify CMS in an ORM termination for 2 months, is this a penalty situation?
So the good news here, I think, is we're going to have plenty of time, a year, right, within which to make those decisions, right? So it isn't necessarily that we have to react within 30 days or 60 days. We have, CMS has given us a lengthy enough period of time to be able to investigate that original denial and perhaps the acceptance of or the settlement of, and then make that decision, right? So if originally denied and then settled, right, we never ever reported ORM, but are going to report TPOC. Let's do the vice versa. We accepted compensability, so ORM on, right? At a certain point, because of medical evidence, no longer causally related, we can terminate that ORM and then still settle. Each of those events will have their own 1-year period within which to report. So we've got plenty of time to make sure that we decipher each and every one of those levels and different components of the file to be able to report them correctly and timely.
Very good. Very good. Seeing no other questions coming in, let's work to wrap some stuff up, guys. So let's share some practice tips with everybody about these issues and put a bow on this before the holiday season. How about that, Jim? As the longtime practicing work comp defense attorney in our group, what's the advice that you've got for attorneys, outside counsel, who are working with organizations that have to tackle these obligations?
Well, I think it begins with paying attention to the details. As our discussion today has illustrated, there's a lot that we don't know. There's a lot that we speculate about, but we see over and over again just wanting to get it done quickly without paying attention to all the little pieces that have to be addressed. So slow down and pay attention would be my strongest recommendation to everyone involved.
Raphael, how about you? What kind of practice tips or advice have you got as parting words for the audience today?
John, and I think Jim hit this on early on, and I think he's so right, which is if you're attending a mediation, get all of those ducks in a row. Right. You know, you're sitting together with opposing side. Let's hash out all of these different minute but important components. Let's talk about, you know, what the ORM date is going to be. Let's talk about the ICDs, Jim, as you mentioned, right? Let's talk about that TPOC date and TPOC amount. Let's write all of that out, either in preparation for the mediation or as part of that mediation settlement agreement now, so that when everybody leaves the room, everybody knows exactly what's going to get reported over at CMS, right? Everybody has a nice blueprint of what the agreement is and all of these details. Because John, you know it, it's the inconsistency that's also going to kill us down the line with conditional payments and MSAs, right?
Absolutely, absolutely is. So my advice, if I'm advising outside defense counsel, first thing I'm going to say is make sure that your client has registered as an RRE. Don't assume that they've even done that. Okay, confirm that that's happened. Confirm they've got a reporting process in place, and then work with them to understand the file in a way that leading up to mediation, they're able to capture the details, agree upon what's going to get reported, maybe consider memorializing that within the clincher agreement itself as an exhibit, so that if Medicare has questions down the road, they can look to the settlement agreement as evidence that supports what was actually being reported, right? You know, there is, for the attorneys out there who are trying to get this right at mediation, this might be a step too far for them. We're happy to help. You know, you can give us a call, consult with us. We can walk you through exactly the questions to be asking, the data to be collecting in that kind of way, because it is important, because what gets reported to Medicare and when it gets reported, you're not just checking a box from the mandatory insurer reporting perspective, but you're also ensuring that your conditional payments are going to be appropriate. You're making sure that the MSA information is going to be appropriate, and Medicare is not going to look for too much money from either side at any point going down the road. You know, we've also got plaintiffs' counsel who have joined us on this webcast today. The advice for them, hey, good news. Medicare doesn't have any penalties with respect to this directly against Medicare beneficiaries or their attorneys. But the potential is there if the RRE, if the carrier, if the employer is getting this wrong, if the data that's going to Medicare is incorrect, invalid, inappropriate, that could have an adverse effect on your client, the Medicare beneficiary. Medicare could come back looking for more conditional payments than perhaps it's owed, and sending those recovery letters directly to the beneficiary without copying counsel on it post-settlement. That's an area of concern for plaintiff attorneys in this area. Starting in April, when MSA data starts to get reported, that's going to have some pin action as well. So while this reporting obligation is insurance defense specific, and Medicare beneficiaries and counsel are not subject to and in line and exposed to these penalties that we've talked about today, there is some indirect bad action that could occur to those individuals and entities if this is done wrong. So be informed, be active as a part of mediation to talk about this, and make sure this is getting on the table, and be collaborative as part of resolving the claim to get this data correct.
Love it, John. That's good stuff, man.
So guys, unless there's other questions, and I don't know that I see any that have come in, I think it is time to put a bow on this quarter's Caddy Gonzalez webcast. I'm going to make one little ask of everybody this holiday season. I'm going to ask, if you've enjoyed this webcast and enjoy the content that we're providing and what we're bringing to the table, I'd ask that you share this with a friend or colleague. You know, we do these webcasts once a quarter. We would love to put this in front of more people to help educate your colleagues and your friends in this area. So I'm going to make that little ask on everybody. Signing off. We'll see you in 2025.
Thank you, guys.